This case was filed by the estate of Andrea Tellez Rojas by her personal representative, Yadira Tellez Rojas. We call her the plaintiff. The case was filed against the Hillsborough Pediatric Clinic, who we call the defendant.
Defense witness is Dr. Mark Buchholz. He is one of the doctors at Randall Children's Hospital.
What do you think, given your review and your clinical experience with pediatric lymphocytic myocarditis, would have been the percent likelihood of Ms. Tellez Rojas surviving if she had been sent to the emergency department either at 3:30 at the end of the visit, or 3:30 or 3:40 at the end of the visit with Ms. Moss, or around 5 o'clock when the lab results were received by the Hillsborough Pediatric Clinic?
I believe the outcome would be the same.
Still a fatal diagnosis.
It would have been fatal.
Let's assume that there are abnormalities in the diagnostics that are run. And let's assume for the moment that the ER physician now sees an indication to potentially consider things like a transport, either via ground or air, or another option, maybe admit Ms. Tellez Rojas to the Tuolumne pediatric floor. Can you walk us through that decision-making process and how long it takes to do all of those things?
Yeah, and we receive phone calls from, from emergency departments all throughout Oregon. And I've done phone calls, is first you have to call the transfer center at OHSU. Then you're on hold and they have to put a call out to the doctor that you would like. If you're going to admit to general peds, if she's not that sick, the patient will go to general pediatrics to find a pediatric hospitalist, or if they are critically ill, to the pediatric intensivist. And that doctor comes on the phone anywhere from 5 to 10 minutes after you call. It varies depending if that doctor is in a procedure, is unavailable. It varies.
So there's a phone call to the transfer center, you're on hold, they get another specialist on the other line, you have a discussion with them.
Correct.
That process takes about how long?
That's another 5 to 10 minutes because that doctor then in the emergency department is recapping the entire course of what they're finding, what the labs are, what the presentation is, and then the ICU doctor or the hospitalist doctor then is taking that information and triaging to determine where that patient goes.
I think we put the number up here, 20 minutes. Should that be less than maybe 10 minutes?
Oh, that sounds about right.
Are you sure? I don't want to put something up if you're thinking it's a little high.
It varies. I would say there's a range anywhere. That could be on the long end. It might be 15 minutes. It's definitely not less than 10, and it's definitely not more than 30.
All right. Then if we run down the ground transport pathway, assuming that a call is made, a specialist on the other end at OHSU accepts the patient for transfer, then there'd have to be the decision to transport the patient via ground, right? How long does that process typically take?
Then the ICU doctor then is dispatching the transport team, and they have to page out the transport team, and then they have to instruct the transport team.
So where's the this would have been the PANDA transport team, is that right?
Correct.
And that's OHSU's Pediatric Critical Care Transport Team?
That's correct.
And so what does PANDA stand for and what do they do?
Pediatric and neonatal air. Pediatric and neonatal I forget what D is, but it was their air transport beforehand.
Okay. And so how long would
Pediatric and neonatal Dornbecker airlift.
And how long would it take ground transport to the PANDA team to go from OHSU Dornbeckers to Tuolumne Hospital, pick up the patient, get them ready for transport, and then take them back?
So then the Dornbecker, because it's at Tuolumne, would not fly, generally wouldn't fly unless they have a breathing tube in and they're being supported on a ventilator. They would fly, or they would drive from OHSU out to Tuolumne.
And how long does that take?
Well, then they have to dispatch, they have to get their gear, then they have to go to the ambulance. For our transfers, we like to be from time of dispatch to out the door in under 20 minutes, which I assume Dornbecker is about the same. And then they drive out to Tuolumne.
Okay. So how long to get to Tuolumne, to get the gear, get the team, get on the road, and then get out to Tuolumne?
So it's 20 minutes from the phone call to out the door, and then Tuolumne is about a 30-minute drive.
And then once they pick up the patient, travel back to OHSU, is that about another 30-minute drive?
And then the transport teams, they're in the hospital, they evaluate the patient, then they call the ICU doctor back with a summary of where the patient is so that we can myocarditis children. Anesthesia comes up, intubates, then you put a central line in and an arc line in.
We know that at 8:47 p.m., unfortunately, there was a sudden change in Ms. Tejas-Rojas's condition, and she was transported to the emergency room at Tuolumne Hospital at that time. In between the time period of 7:50 p.m., or a little bit earlier, because we do have to account for the fact that the discussion with the transfer center would have been slightly shorter. Between the time that supportive treatment was initiated and the time in which she had a sudden change in her condition, would there have been indications for ECMO?
No, not on the vital signs that she presented with.
And why wouldn't there have been an indication for ECMO later on in the evening? What is the indication for ECMO? Can you explain that to us?
It's blood pressure or arrhythmias that are not effectively treated with medications.
And the patient would have to crash first before they get put on ECMO.
We like to put them on before they crash, but that is a judgment call because the normal ejection fraction of the heart is about 65 to 68% of blood that comes in gets squeezed out. Children are resilient and they can tolerate down to low levels, typically down to 20, I think I was down to 20%, 22, 23%, so really down. And then it's in the single digits where we're discussing, do we put them on ECMO or not?
So with this time course, assuming that indications were there for each of these things at every step of the way, would there have been a change in the outcome if at the beginning of this time course, Ms. Moss had sent Ms. Tejas-Rojas to the emergency room after the visit?
No.
Okay. Now, the other time point, before we go, or move on to the next slide, can you explain to the jury exactly what the role is of an ER physician, the role of ER nurses, and the role of an ER tech?
The ER physician will assess, diagnose, treat, and coordinate all of the care and be responsible for all of the care of that patient. It is a very much a team approach where the ER physician is taking information in from the nurse, who is also placing IVs, obtaining labs, putting patient on monitors, as well as giving feedback to how the treatment is proceeding. The ED tech is often doing procedures, and each hospital has different rules and qualifications for the ED tech for what they're doing. Oftentimes it's vital signs, placing an IV, rooming patients.
And in terms of the things that would have been done at 4:30, what would have been the role of an ER tech, someone like Mr. Zamora, who we heard from earlier in this trial?
Typically ED techs aren't licensed to give medications, but they will perform EKGs, put patients in a room, gown, clean rooms, have everything ready, assist with spinal taps, placing IVs, be involved with patients.
So they're involved in more of a supportive role?
Yes.
Okay. Let's talk about what the time course would have been at 5 o'clock when the lab results would have been received. Still, if she had been sent to the emergency department at 5 o'clock, still the same scenario on the front end in terms of needing to be triaged in the waiting room and the practical reality of a patient going to the emergency room these days.
That's correct.
Same workup, 1 hour later?
Same workup.
Okay. And assume that workup had revealed abnormalities and an indication to transport, and we'll adjust this so that the transfer center call is shorter, 10 to 15 minutes. The same amount of time to coordinate and facilitate these things in terms of the transport.
Yes, might even be longer because with that presentation, oftentimes folks may do a CT, so CT chest, to look for PE, which is much more common.
Okay. And you talk about the presentation as described by the ER technician, or not the ER technician, the lab technicians who obtained the blood culture that night for Ms. Tejas-Rojas.
Right, on the room at that 6:10.
Okay. I think that was earlier when the lab results were pulled. Okay. And then in terms of the subsequent timeline, assuming that there had been an indication for transport, still the same outcome.
That's correct.
I don't have any other further questions. Thank you. Specialist in pediatric critical care, do you think the blood pressure would have been normal if it had been taken at the time of the visit with Ms. Moss by Ms. Sarah Ewan?
Yes,
Can you explain to us exactly why you hold that opinion?
because cardiac output from the heart is dependent on the amount of blood it's pushing out as well as how fast the heart rate is. And therefore you look at heart rate times how much blood is coming out. and then you look at end organ. With a normal perfusion, warm, good pulses, good urine output, mentating well, the end organs are getting enough blood. That means that the heart rate times the amount of blood that's being pushed out, which is blood pressure, has to be normal. With a normal heart rate, the blood pressure has to be adequate.
And so no signs or symptoms at the time of the visit that Ms. Tejas Rojas was critically ill?
That's correct.
No signs that she was in cardiogenic shock or an imminent risk of developing cardiogenic shock in the short term?
That's correct.
And no signs of any emergent medical conditions at that point in time?
That's correct.
If she had diagnostic tools available such as EKG, telemetry, those would have picked up on any cardiac abnormalities.
It may or may not.
Okay. At some point, it would have picked up on cardiac abnormalities given that she crashed at 8:30.
It may have picked up at the moment she crashed.
So are you saying it's possible that she had no cardiac abnormalities until she crashed at 8:30?
That's correct.
It was just sudden 8:30 cardiac arrest.
That's correct.
Is lymphocytic myocarditis a progressive disease?
It can be progressive or it can be fulminant. It can be super acute where it hits the electrical system and you go into VFib and fatal.
But you're making an assumption, correct?
In the patients that we've seen, that's correct.
How many patients have you treated with lymphocytic myocarditis?
The myocarditis, probably at least 20.
Have they all survived?
No.
And you said there's a 1/3, 1/3, 1/3 split. 1/3 survive, right?
Correct.
1/3 survive with long-term issues,
Correct.
and 1/3 inevitably it's fatal.
Correct.
So there's a 66% survival rate.
That's the statistics, and that's generally what we see.
And do you have an opinion on whether, had Andrea received supportive care earlier, is there any reason she wouldn't have fallen into that 66% survival rate, even if she would have had long-term complications with her heart?
No, I think the ones that die of ventricular fibrillation and arrhythmias, not of heart failure, for which there's medications, but there's not a good treatment. So I believe that the third that die, they die from rapid arrhythmic cardiac arrest.
Is there a point in time before 8:30 on August 12, 2020 that you believe Andrea would likely have survived?
No.
You
I think
believe
that
it's
would be
inevitable,
very unlikely to have survived.
even if she were administered ECMO
There is no reason to administer ECMO.
after she crashed from cardiac arrest?
Well, after she crashed, now she's into eCPR, and that is not available.
And you're familiar with a study, I believe we were provided with materials by Mr. Young, some of your handwritten notes. And in one of your handwritten notes, you cited the AHA journal, and that's a reliable authority, correct?
The AHA journal is a reference, among others.
From the American Heart Association?
It is one of the references that we use. For example, PALS is an AHA reference, Pediatric Advanced Life Support, which was the algorithm used for the treatment of this patient.
And you cited a specific journal article, the AHA Scientific Statement, Diagnosis and Management of Myocarditis in Children. Is that right?
Can I look at my notes?
Sure.
Which one?
Is it your handwritten note? AHA journal?
Correct, with the treatment of arrhythmias,
And this is the exact article that you cited, correct? Diagnosis and Management of Myocarditis in Children?
which I did not pull the article because I don't have authority, or I can't pull the article, so I would just look at the abstract.
It looks like you quoted from it. It is unclear whether treatment of myocarditis lessens development of arrhythmia. That's directly from this article, isn't it?
Well, it is, but when you Google it and you look at it, it holds the top statement. Those are paid for articles, which I don't have.
Do you agree that this article would be a reliable authority in the field of critical care medicine?
I think it's an article that has a study, but I did not read the study. I just did what Google gave me.
Okay. Would you agree that ECMO support has a 69% to 76% survival rate?
From the ELSO registry, that is the statistic that we use if they are able to get on ECMO.
Do you agree that ECMO is an attractive choice for mechanical support because it can be deployed emergently and because the probability of a brisk cardiac recovery in myocarditis is high?
Well, it's the definition of deployed rapidly. And how rapidly? If it's with CPR, that's too late. Because few centers in the nation do pediatric eCPR, and the outcomes can be very poor without of hospital cardiac arrest. In the hospital, can be slightly better, if it's available.
You were hired by Mr. Young to testify in this case.
To give my opinion, that is correct.
Have you worked with Mr. Young on any other cases?
I reviewed about, I want to say 8 to 10 years ago, I reviewed a case. That was the only one. Generally, I review criminal cases for child abuse.
Have you reviewed any other cases for the Lindsay Hart law firm that Mr. Young works for?
Not that I recall.
Do you know how Mr. Young obtained your contact information?
From another attorney, which
Who is the attorney?
I cannot recall.
And has Mr. Young or anyone from his law firm represented you in any malpractice cases?
No.
Are you aware that Mr. Young's law firm has represented Legacy Health System in medical malpractice cases?
Object to the relevance, Your Honor.
You're an employee.
Oh, wait, go ahead. Folks, as I explained at the very beginning, questions are not evidence, so I'm instructing you to disregard that last question. Mr. Woods is going to move on.
Thank you, Your Honor.
Thank you.
At Legacy, you have diagnostic tools available to reach a diagnosis for lymphocytic myocarditis, correct?
The machines are available.
Right. EKG,
EKG is available.
echocardiograms are available,
Not immediately.
not immediately.
No, the machine is available, but the Echo Tech is not available 24/7.
And
They are available. They have to come in.
if Andrea, if she had any cardiac abnormalities that were detected after she were admitted to the hospital, there would be pediatric cardiologists available to consult, correct?
They are. They're not in-house. That is correct.
And you're a critical care pediatrician.
That's correct.
So patients do not see you unless they're in critical condition, correct?
They're admitted to the ICU. Their condition can vary from serious to critical to, yes.
And you'd agree that there are pediatric patients that are diagnosed with myocarditis that don't end up seeing you because they receive management for myocarditis.
No, not generally. Folks with myocarditis would generally be, in our experience, in our patients, admitted to the pediatric ICU.
So anytime a patient has myocarditis, they're admitted to the ICU.
Because of ventricular arrhythmias, which can be fatal, and it can be progressive. It can be fulminant.
Are you aware of any cases where a pediatric patient has been diagnosed with myocarditis that did not end up in the ICU?
During COVID, we had the MISC patients, which can be a variation, have myocarditis-like symptoms. Those were initially managed on the floor, but in general, the myocarditis patients would be admitted to the ICU. Are there patients on general pediatric floors with myocarditis? We're not consulted on, and the cardiologist could be in the loop, but I'm not in that loop.
And you reviewed Andre's lab results that were resulted at 5 p.m.
I did.
If you could pull that up, exhibit 6A, please. If you could zoom in on the creatinine kinase results at the top there, Jake. Thank you. That's the comprehensive metabolic panel immediately above that. Andrea's creatinine kinase was abnormal, correct?
The CK is abnormal, that's correct.
All right. And what was the creatinine kinase value at 5 p.m.?
Is it, where is it? Oh, there it is, it's at the top, it's not in the big set. It is
Zoom in on that, please.
406, 476?
486.
486.
That's elevated.
It is, it's not that elevated for the patients that we see.
And creatinine kinase, as we've heard, is non-specific but can be an indicator of muscle damage, correct?
That's correct.
And the heart is a muscle.
The heart is a muscle, so it would be in the broad CK. Generally, we don't order CKs for the heart. It's more skeletal muscle.
Okay. But an elevated CK could be consistent with damage to the myocardium of the heart or inflammation.
It would be in that spectrum, yes. The CKs are not done anymore for hearts.
What other diagnostic tools are available to lead to a diagnosis of myocarditis?
Troponins would be, troponin has replaced CK. Generally, a CK is sent to look for muscle injury, for a myositis, muscle inflammation.
And troponin, that's a biomarker, right?
Correct.
And it's specific to the heart.
It is much more specific.
And that wasn't ordered in this case.
There was no troponin, that's correct.
Can you infer that Andrea's troponin would have been elevated had it been ordered by Ms. Moss?
No.
Why?
Because the patient did not have evidence of poor cardiac output with the heart rate being low, perfusion being good. There wasn't clinical evidence that there was ongoing cardiac injury. Could it have been slightly elevated? It could have been. It could have been normal.
Are you aware of Ms. Ewan's testimony about how Andrea's heart rate was measured and recorded?
That's correct.
She listened for 10 seconds and multiplied by 6? That can lead to inaccurate data, right?
Not necessarily. The heart rate is very specific. I mean, it's consistent. Even on monitors, it does not rapidly change. It is consistent, similar to a speedometer in a car. It is gradually goes up, gradually comes down.
Do you take heart rate measurements in your practice?
What I will do is generally when a patient arrives is feel their pulse and feel their pulse for about that 10 seconds to feel the heart rate, pulse pressure, and perfusion.
So it's your opinion that Andrea would not have had any detectable heart abnormalities until she crashed at 8:30 p.m.?
I think there is a chance she could not have had any abnormalities. There is that chance.
And that is an assumption that you're making, correct?
That's been my experience. That with electrical activity, arrhythmias from myocarditis can present with essentially no warning.
You were interviewed by the Oregon Public OPP, right? Back in May of 2020?
Was that for the MISC patient?
Yeah, the multisystem inflammatory syndrome.
Correct.
And that was a case, let's see, May 2020, 3 months before Andrea passed, right?
Correct. That was the first case of MISC in Oregon in a pediatric patient.
Okay. And she had some type of systemic inflammatory condition?
She did. She had COVID, fevers, elevated inflammatory markers.
And during the interview, you said her blood pressure was very, very low, and she was essentially in shock and cardiac failure when she came in to her primary care doctor. Is that right?
It sounds right, but if that's the transcript, then yes.
And measuring a patient's blood pressure is important to determine if there's some underlying cause of their condition, correct?
Depending on how they look, I've worked. Blood pressure is a finding, but most importantly is what the end organs are seeing.
When you say depending on how they look, you mean depending on if they look sick?
Mental status, perfusion, heart rate. By far and away, the biggest one is the heart rate. Blood pressure can be a challenge in pediatric patients due to the cuff size, the technical limitations.
You were also quoted as saying, our cardiologist examined her heart, and the heart was inflamed and quite injured. How did your cardiologist examine the patient's heart and determine that the heart was inflamed and quite injured?
That should have been, I suspect that was from an echocardiogram.
So the echocardiogram would have shown this patient to have an inflamed and injured heart.
On that patient from MISC.
Why are you assuming that it wouldn't equally have been shown on an echocardiogram of Andrea?
Well, MISC is different, can be different from myocarditis, lymphocytic myocarditis. But it's the electrical, the arrhythmias that are the issue. So could it have shown? It could have, but she wasn't in congestive heart failure. And I'm sure my physical exam of that patient had elevated heart rate, poor perfusion, and poor urine output.
But in this patient, an echocardiogram showed that she had inflamed and injured heart, correct?
I suspect that is, I'm not reading it, so I can't validate it, but
These
that's
are
what
your
it
words.
says.
These are your words that I'm using.
Correct.
You did say that to OPP, correct?
Correct.
Buchholz said families should watch out for similar symptoms present in young people, generally unexplained high fevers. Didn't Andrea have unexplained high fevers?
She had a fever, but not at the time that she was seen. She was afebrile.
She had 10 days of intermittent fevers, correct?
Correct, and she was COVID negative.
Right, so her 10 days of unexplained high fevers, that Andrea had that, right? Was there a clear diagnosis on August 12, 2020?
She had periodic fevers that were documented. Did she have fevers every day? That I can't validate.
And intermittent fevers can be a sign of an underlying systemic infection or inflammation.
It can be a sign of many. It can be a sign of you got one, then you got another, then you got another. It can be a sign of underlying autoimmune inflammation. It can be a sign of infection. So it can be a sign. That is correct.
And you also said that they should be on the lookout for abdominal pain. Andrea had abdominal pain, right?
She did have abdominal pain. That is correct.
And children should be brought in as soon as possible if they are seeing unexplained symptoms. Those are your words?
If that's what I said, that's correct.
Andrea had 10 days of unexplained symptoms and an unclear diagnosis. You'd agree with that?
She had a different presentation than that patient right there. She did not have evidence of heart failure.
Is Mr. Young paying you to be here?
I have taken the day off of work to be here, and I'm being reimbursed for that. Yes, I am.
So the answer is yes, you are being paid to be here.
Yes.
How much are you being paid?
The same hourly rate for the last 12 years, every once or twice a year. Once a year I do this. $4.25 an hour.
Those are all my questions. Thank you.
Redirect.
Thank you, Your Honor. Dr. Buckholz, in your review of the notes, Ms. Moss had a plan for Ms. Tejas Rojas, right?
She did. She had a plan.
She was ordering labs to further evaluate what she saw in the clinic on August 12, 2020, right?
That is correct.
And the unfortunate tragic reality is that while those lab results had come back and she was planning to follow up with Ms. Tejas Rojas, her patient unfortunately passed hours later, right? But based on what she saw in the clinic visit that day, there was no way that she could have foreseen that, right?
No.
Okay. And MISC, what is MISC?
Multi-system inflammatory, severe COVID, multi-system inflammatory COVID response, MISC. We don't see it very often anymore. So multi-system inflammatory syndrome from COVID. And it affects all organs.
And probably self-explanatory. Multi-system organ failure from systemic illness, systemic inflammation, right?
That's correct.
Vastly different and separate and distinct from a entity that is specific to the heart, like a lymphocytic myocarditis.
It's apples and oranges. It is a different entity.
Okay. And here, what distinguishes Ms. Tejas Rojas' case from this unnamed MISC patient that was the subject of your interview with OPB is that Ms. Tejas Rojas had specific findings on a forensic pathology exam that confirmed lesions on her heart.
That's correct.
Okay. Another thing that distinguishes this case from that one is that she had a normal chest x-ray.
Correct.
Okay. She had a sudden and acute change in presentation that happened after she left the clinic, leading up to the time that she presented to the emergency department that night.
That's correct.
Okay. And counsel asked you about some data in the ELSO database, and he asked about some specific numbers. The numbers 69%, 70-something%, I don't want to misquote you. But those numbers are from the database for all types of pediatric myocarditis, right?
They're for all types of patients.
Okay. And that data, that statistic is not stratified between the different types of patients or the different types of myocarditis that can be seen in a pediatric patient.
That's correct.
One of the subsets of myocarditis is something like this, lymphocytic with a sudden acute fulminant presentation.
Correct.
And that data is not reported in the ELSO database.
Not that, no.
So even though that might not be reported in the ELSO database, you do have your clinical experience being on the front lines at the bedside, seeing and treating myocarditis patients in the PICU, correct?
That's correct.
All right. And based on your experience, patients with this presentation, where it comes on with a viral syndrome, there's a sudden change, an acute worsening of their condition that turns into heart failure, ventricular fibrillation, and cardiac arrest, that is a presentation with pathology findings that is often fatal.
Yes.
The rule of thirds also that you talked about, third that survive, third have long-term sequelae and complications from myocarditis. The third that is fatal, most of the patients that are in that third are patients like this, right?
Correct.
Okay. Thank you, Dr. Buckholz. Appreciate your time.
Thank you. Either of you need him to remain
No, Your Honor.
ready, available? No? Okay. Thank you. You are excused.
Thank you.
So the reason why I focused a lot on Dr. Buckholz is that I clearly remember sitting there, it's the end of the week, and just sitting there thinking, if I did not work in healthcare, I would be believing every single thing that they are saying. Now, I thought about, in the moment was in my mom's deposition when Jeff Young goes, so it was sudden then, a sudden change. He was basically, it was basically like a relaxed, like sudden, because that's what they're going to keep saying, that it was sudden, that there was no symptoms at the clinic, and it's just inconsistent with a lot of things that we found. And you know it's really interesting because like some of the things that Dr. Buckhold was saying, it's like when I got my when I went to the hospital because I needed 15 stitches in my knee, like I knew I was going to wait 6 hours. And they're trying to say how long, they're going to elongate. They're basically elongating this whole time frame of, they're just trying to, like, Andrea would not have been waiting there for 6 hours. This was a sick kid. And just kind of like, not only did we have to prove, if we were to win the case, like if in order for them to lose the case, one of the things is that, even if Kelsey Jo Moss and Hillsborough Pediatrics was found to be negligent, if they hit yes, they would also have to say yes that Andrea was going to survive at least, the next day. And so they are trying to basically say, even if we found Kelsey Jo Moss guilty, if they put on a case for the jury, and they vote that she was going to die anyway, they would have still found her not guilty. So that was very important for them to keep saying she was going to die. She was going to die anyway. If you find her guilty, but she was going to die anyway, we are still off the hook, essentially. And because defense wanted to dismiss the claim, they were slowly trying to just take out one pillar, discredit whatever they can do to shut this case down. So
we're at the end of plaintiff's case. Ms. Bushnick or Mr. Young?
are you prepared to hear argument on the directed verdict, Your Honor?
Yeah, I have not, I have gotten through part of your motion, and none of the declaration with the associated testimony. So my understanding is that you are moving for a directed verdict only as to paragraph 15A, which is failed to offer or provide an interpreter to Andrea's mother, Martha, during Andrea's August 12th, 2020 clinic visit.
That's correct, Your Honor.
Okay, and not the other three allegations.
That's correct.
Okay. The plaintiff just got this also. Is the plaintiff prepared to argue?
Yes, Your Honor. We can move forward.
Okay. Okay. And recognizing that I have not read all of the details of what's in your motion, though I did skim it. Well, I read the first few pages, skimmed the rest before I had to come back out here. Go ahead with your argument.
Thank you, Your Honor. Directed verdicts are permissible under RSCP 60. A directed verdict is appropriate when there's a complete absence of proof on an essential issue. Here, plaintiff's allegation in 15A alleges that Hillsborough Pediatric Clinic was negligent in failing to offer or provide an interpreter to Andrea's mother during the August 12, 2020 clinic visit. Here, defendant is not asking the court to weigh the evidence or evaluate witness credibility. The inquiry for the court is whether plaintiff has met their burden of proof in demonstrating not only that HPC was negligent in failing to offer an interpreter, but connecting that negligence to causation. So in other words, that Andrea would have survived had an interpreter been offered. I cited a number of cases.
Let me just pause you there for a second.
Yes.
Do you agree with the standard?
The standard for a directed verdict?
Well, the standard for a directed verdict and that what you have to prove is that you have to connect each allegation of negligence to the cause of Andrea's death. In other words, that but for not having an interpreter, she would have survived.
Yeah, I agree, as long as we're gonna be able to talk about what reasonable inferences can also be drawn from
Oh,
evidence.
yes. Yeah. I'm trying to focus on what you each agree and disagree on. So that's the standard, is that the plaintiff has to provide evidence that it had been offered, if Ms. Osorio had been offered an interpreter at the August 12th visit, and an interpreter had been provided, that Andrea would have survived.
Yes.
Okay.
Thank you, Your Honor. I cited a number of cases. The court is aware that in a medical malpractice case, unless in very limited circumstances, that there's expert testimony is required to link negligence to causation. Expert testimony is not sufficient to establish causation unless it shows with a reasonable degree of medical probability there's a causal connection between the defendant's actions and the injuries alleged, which here is Andrea's death. There have been 4 experts in plaintiff's case in chief. Dr. Anthony Chang, who's a pediatric cardiologist. I offered Dr. Chang's transcript just for the purpose of the court being able to confirm. Dr. Chang didn't speak to the issue of a translator at all. The word translator interpreter does not appear in his transcript. Dr. Alexander Hamling is a pediatrician. He testified regarding the negligence of failing to have an interpreter, but he did not link that negligence in any way to causation or testify that had an interpreter been offered, the outcome would have been different. Mr. Zamora, who had sort of a limited purpose as an expert, likewise did not testify to that. He testified in general terms about interpreters, although he was not permitted to testify on standard of care. So he offered no testimony on this issue, and Maureen Jones likewise testified, like Dr. Hamling, that it was below the standard of care to not have an interpreter, but did not link that to whether the outcome would have been different. So without providing admissible testimony from an expert to connect the allegation of negligence to causing Andrea's death, plaintiff has failed to meet their burden of proof as to that allegation. And I provided an example of a case that also involved a directed verdict, Brown versus Portland Adventist Medical Center, 254 or App 73 from 2012. And in that case, the plaintiff alleged that the hospital and the emergency room physicians were negligent in failing to obtain a second troponin test to evaluate and diagnose a heart attack. And in that case, so the inference would be that had one been done, they would have diagnosed his heart attack. Instead, they sent him home, and then later he found out he had a heart attack and bad things happened. There was expert testimony in that case that a second troponin would have shown that the plaintiff was experiencing a heart attack. So in other words, in that case, there was a link between the alleged negligence and how that negligence impacted causation. Because in that case, where the expert testified that the troponin would have showed a heart attack, that means that then the patient would have been treated for that heart attack. Here, there's no evidence from any expert that providing an interpreter would have changed the outcome. And in addition, to the extent that plaintiff cites to the sort of inferences based on the factual testimony, the fact testimony likewise does not establish any element in terms of causation. Ms. Rojas Osorio testified multiple times in her direct exam and on redirect that Ms. Moss did not tell her about going to the emergency department. Ms. Osorio testified that Ms. Moss spoke to her in Spanish, that Ms. Moss instructed her to go to the lab and instructed her to go to the pharmacy. And her position is that Ms. Moss simply did not tell her to go to the hospital. And that goes to plaintiff's third allegation of negligence, paragraph 15C, that Ms. Moss should have sent her to the hospital. And we've heard about expert testimony on that. But nowhere did Ms. Rojas Osorio testify that had an interpreter been offered, something different would have happened, because from her perspective, she was just never told to go to the emergency department. I would also suggest to the court that that also wouldn't necessarily be sufficient because there needs to be expert testimony. But be that as it may, Ms. Rojas Osorio did not offer any testimony that had she been offered an interpreter, that she would have understood the plan a different way. She was very clear that Ms. Moss told her the plan, and her belief is that Ms. Moss just didn't tell her about going to the ER. And for that reason, because there's a complete absence of proof on that element, linking negligence to causation, which is also one of our motions in Lemonade that plaintiff agreed to. If I can find which motion that was. Well, I know I cited it. Oh, motion Lemonade number 2, to connect negligence and causation. without any testimony on that topic, that allegation of negligence should be struck and should not be at issue in this case. And I've asked for a limiting instruction in that regard as well.
Okay.
So a couple of things right off the bat, Your Honor. When something is within the purview of a lay person, and it's appropriate for the jury to ascertain it's within the purview of a lay person, expert testimony is not always required on the causation element. And I can cite to you this, and I can give you the site. It's 159 ORAP 637, and in that case, they said that
159 Oregon Appeals 637.
637, yeah, and he's citing the 637 at 642, and that in that case, expert medical testimony was not required when it was within the capability of a jury to ascertain that a clamp is not normally left inside a patient unless someone was negligent. So in this case, it's totally within the purview of a layperson to decide, based on the factual testimony, that, and it's a reasonable inference, that if she had been, and Ms. Moss is stating that she did say, if you get worse, go to the emergency room. If she had understood that plan and taken her to the emergency room, she would have been on a different trajectory. This was the testimony of Dr. Chang. If she gets into the emergency room earlier in the afternoon, she might not have decompensated at all, because she would have been given IV medications, IV diuretics. She would have had a good chance of having a diagnosis made at the ER at that time. And so it's totally a reasonable inference for the jury to connect those dots. And in addition, there's factual
Are you
information.
saying that Ms. Moss said that she should go to the emergency room now?
No, Ms. Moss was said that the plan that she communicated, and she testified to the jury in Spanish, that she said, if you get worse, go to the emergency room. That's different than the set of facts that Ms. Osorio testified to, which she says that didn't happen. So that's totally a factual question for the jury to decide who said what in that appointment, and then it's a reasonable inference to decide, would that have changed the outcome? And that goes to our causation expert, which was Dr. Chang, right? Because if he's testifying, if you get her to the emergency room earlier, outcome would have been different.
And did Ms. Moss testify to that on direct?
She testified to that on direct. I think Mr. Young asked her, so did you say, is it your
No.
common practice?
No, you called Ms. Moss, right?
Oh, yes. We did call Ms. Moss.
Okay.
And she,
So did Ms. Moss testify on your direct examination?
Right.
That she told her, I know that I heard it,
right.
I don't remember exactly when or who was doing the questioning.
I believe
Did she
that.
testify on your direct examination that if you get worse, go to the emergency room?
I have not read the transcript, but my memory is that under questioning by Mr. Voorhees, she said it is my common practice that when people leave my office or leave the care, I tell them if things get worse, go to the emergency room. I think she said that multiple times. That's my standard practice.
But did she say that then in response to questions from Mr. Voorhees?
Yes, I believe so. In our case in chief.
I mean, the distinction here is whether you presented evidence in your case in chief. Doesn't matter who's witness. Doesn't matter where she's sitting at the counsel table.
Right.
It's whether you presented evidence in your case in chief linking the two. So if it came up in cross-examination, then I think that gets viewed differently than if it came up in the direct examination of one of your witnesses.
If the information was elicited on cross during our case in chief, that would have a different weight than if it was elicited on direct examination.
Quite frankly, I'm not sure, but it is viewing. Well, it came up in cross-examination of one of your witnesses. Maybe not. Maybe not. I'll deal with that. But go ahead.
And then there's also other facts that go to the weight of this evidence that Ms. Osorio typically, and there is evidence in the record to this, that she followed the doctor's orders. So on the August 5th visit, they were released, went home, they quarantined. That's exactly what Ms. Moss counseled them to do. If things got worse, she went to the urgent care. They went to the urgent care. They said, follow up with your PCP in 2 to 3 days. That's exactly what the family did. So and Ms. Osorio took her daughter to all the well visits at Hillsborough Pediatric Clinic. So it was her common practice to do what the providers had instructed her to do. And I think a reasonable inference from all that evidence cumulatively is that if a translator had been provided, the outcome could have been different because, as Dr. Chang testified to, we would have had a different trajectory of the illness had she been in the ER.
Okay,
Can I respond,
Ms.
Your Honor?
Bushnick?
Thank you. So I actually think that on some points we agree that Ms. Osorio followed the doctor's instructions when she would see Dr. Gutierrez. That in this particular instance, she followed the instructions to go to the lab and to take Andrea to the pharmacy. She did those things. There is no evidence on this record that there was any confusion by Ms. Osorio about the plan. She testified she knew she could ask for an interpreter. She felt she didn't need one because Ms. Moss spoke to her in Spanish. Her testimony was not, if I had an interpreter, then I could have known about going to the ER. Her testimony is that Ms. Moss didn't tell her to go to the hospital, period. And that is a different allegation of negligence. That is in paragraph C, that Ms. Moss should have sent her to the ER. So there is no evidence from any of the testimony on this record, irrespective of what Ms. Moss says she told the family. There's no evidence that Martha had any confusion about the plan or that an interpreter would have changed what she did, because her position is that she just wasn't told to go to the hospital.
Well, but if Ms. Moss told her go to the ER if needed, and Ms. Osorio says, I never heard ER, well, there is confusion about the plan. I mean, it's if Ms. Moss said, yes, I always tell them, go to the ER if it gets worse. Okay, so if her testimony is to be believed, then she did say that. And so if Ms. Osorio is saying she didn't say it or I didn't hear it, well, there clearly is confusion about the plan.
I disagree, Your Honor. I think the issue is that Ms. Osorio simply said, it's not that she was confused because of a language difference. It's a factual dispute about what Ms. Moss said or didn't say. And I assume that plaintiff is going to argue that had Ms. Moss told them to go to the ER if Andrea felt worse, they would have done that. That's what I assume that the plaintiff is going to argue. And so the inference to be drawn from plaintiff's perspective, based on Martha's testimony, is that Ms. Moss just didn't tell them. And that has nothing to do with whether there was an interpreter. There's no evidence on this record that Ms. Osorio was confused because of failing to have an interpreter. There's just a factual dispute about what Ms. Moss said, and those are two different things. And I'd also add, first, that plaintiff isn't prejudiced by this directed verdict because the ultimate point, which is she should have sent them to the hospital, is still contained in their allegations of negligence. And in addition, the cases that were just cited are res ipsa loquitur cases. And that's the sort of small category of cases that I mentioned at the very beginning of my argument.
You mean the Clamp case?
Yes, where expert testimony might not be required because there's a presumption of negligence in these sorts of very limited circumstances, like where you leave something in somebody's body during surgery, you cut off the wrong leg during surgery or something like that. This isn't one of those cases. And like I mentioned, the plaintiff has already presented standard of care evidence from experts on the interpreter issue, but there's no evidence before this court that there was a miscommunication, that Ms. Osorio didn't understand because of a language issue. It's very different. Her position is that she just wasn't told to go to the hospital, and that's a different allegation of negligence.
And I mean, I would agree with the defendant that the Clamp case, which I remember actually, is quite a lot different than failure to provide an interpreter case. Do you have any case law that is closer to the factual situation here?
I don't, Your Honor, about the use of an interpreter, but I will just say that I think there's a factual dispute here. We have one person in a room that says one thing was said, another person that was in the room that says another thing was said, and if that should be a question for the jury to decide what happened, and then what is the reasonable inference to be drawn from those facts. And if it, based on plaintiff's causation expert, that would change the outcome if they decide that the interpreter, had an interpreter been there, Ms. Moss could have more clearly communicated the plan, she would have been in the ER sooner. That's the inference that can be drawn when looking at the facts in their total. if we're just, if that's all they need to do, and it's a reasonable inference to be made from the record.
I'm trying to think. I didn't read all through the transcripts that are appended to the defense motion. I did read the excerpts in the motion from Ms. Osorio. And it sounds like you're not disputing what she said.
No, we're not disputing what she said.
Okay. So your position is that if Ms. Moss's testimony is to be believed, and if what Ms. Moss says that she told Ms. Osorio was interpreted into Spanish, then Ms. Osorio would have heard that in Spanish and would have known that the emergency room was an option if Andrea didn't get better.
Right. She would have known that was the plan. She would have known that the provider was thinking that she's the mother, the decision maker, should be aware that her child's been sick for 10 days. If she gets worse and worse, she needs to go to the emergency room. And according to Ms. Osorio, that wasn't even discussed. She didn't say any of those words. So, and when you look at things in combination with our causation expert, they go together. Because had she been in there earlier, we had a different trajectory of the illness.
I mean, you don't know what she would have done.
We don't know what she would have done. We don't know, right? Because that didn't happen. So that's one of our allegations, and that's a question for the jury to decide. It's a reasonable inference from the facts on the record.
Anything else from defense?
I would simply say it's not a reasonable inference based on Martha's testimony that she understood the plan and based on the evidence that she followed the plan. The inference to be drawn is that there's, according from Martha's perspective, is that she simply just wasn't told to go to the ER, which is a different allegation of negligence.
But what if she's saying that because when Ms. Moss said, if she gets worse, go to the emergency room, that she said it in bad Spanish, and the reason she didn't hear emergency room, and Ms. Moss testified that she was telling her in Spanish what the plan was. So what if she just didn't understand the words that Ms. Moss used for emergency room and thought it meant, go to Fred Meyer or whatever. And that's why she said that she wasn't told that.
I would suggest to the court that could have been something that plaintiff elicited during Martha's examination, and they simply did not. Instead, counsel repeatedly asked, do you remember if Ms. Moss instructed you? Did she ever say the words emergency room to you? She never said, was the response. In the medical appointment with Andrea, was the appointment primarily in English with Andrea talking? No, the doctor was speaking Spanish to me too. As you sit here today, you're confident that Ms. Kelsey Jo Moss never said the words to you, emergency room, during the August 12th visit. Response, she didn't mention that, I'm sure. She didn't mention it. There was no discussion. Is it possible that you could have misunderstood? Is it possible that you just don't remember? Is it possible that Ms. Moss's Spanish was so poor that you couldn't understand her instruction? The testimony was that she didn't say it, and that's a different allegation of negligence, and that doesn't go to any misunderstanding, miscommunication, or interpreter issue.
Okay. Do you want to respond to that?
The burden is what more likely than not happened during that meeting in the patient's room, and we have a factual dispute here where the provider's saying, I communicated in Spanish the plan to get worse. If it gets worse, go to the emergency room. The Spanish-speaking mother, who doesn't have the benefit of an interpreter, says she didn't say anything close to that. That should be a question for the jury to decide what happened in that visit, And then the reasonable inference would be, well, if she had had the benefit of communicating in her own language with the medical provider through an interpreter, the outcome would have been different.
And would the defense agree that if there is a factual dispute, that then a motion is not right for a directed verdict?
I would say that's true for allegation C about being told to go to the emergency room, not about the interpreter issue, Your Honor.
Well, but there's a factual dispute about what Ms. Moss said.
Right. There's not a dispute about whether Martha understood the plan. That's not in dispute.
Well, yeah, it is. I mean, if Ms. Moss was saying the plan is go to the lab, go to the pharmacy, and if she gets worse, go to the emergency room. If Ms. Moss's testimony is that was the plan, and Ms. Osorio either didn't hear or didn't understand that go to the ER part of the plan. So there is, if Ms. Moss's testimony is to be believed, is a dispute about whether that was communicated to Ms. Osorio. Now, I agree that the way that the questions were asked, and the way that Ms. Osorio answered them, is that she never told me that. But Ms. Moss is very firm that, yeah, I did tell her that. So there does appear to be a dispute, a factual dispute about what plan was conveyed. And if there's a factual dispute, then it would not, if it's a factual dispute on a material element, then it wouldn't appear to be appropriate for a directed verdict. That's what I'm trying to.
I respectfully, Your Honor, I disagree that because there's no link on causation, there was no testimony from Ms. Rojas Osorio that if she had had an interpreter, something different would have happened. They could have elicited that testimony from her, and they didn't. Instead, the testimony suggests, and the inference to be drawn, is that to me, Your Honor, it actually is irrelevant of what Ms. Moss testified to, because the inference to be drawn based on the record and based on the testimony of the family is that if they had been instructed to go to the ED, they would have taken her. But the fact that they followed the plan in terms of going to the lab and going to the pharmacy, I assume plaintiff will argue means that they understood the plan and that Ms. Moss just never told her to go to the emergency department, and that's a different allegation of negligence. The point is that there has been no link. I mean, like I said, Dr. Chang never even mentioned an interpreter. He never mentioned a translator. Yes, he talked about if she had been in the ED earlier, what would have happened. That goes to allegation C, not A. The point is that there has been no testimony from any expert linking the interpreter issue, failing to have an interpreter, to going to the hospital.
We're back on the record. Outside the presence of the jury. And I don't think that either of you sent me anything over the lunch hour. Did you? At least I didn't check my Gmail account, but nothing came to my OJD account. Okay. I see heads nodding no.
Yeah, no, we didn't.
No, we didn't say anything, Your Honor.
Or heads shaking no, I guess. Nodding would be okay, and I've reviewed my notes on the arguments that you made prior to lunch, and I have reviewed the case law, and I am going to grant the defendant's motion for a directive verdict in terms of allegation A, I guess we'll call it 15A, that the defendant failed to offer or provide an interpreter to Andrea's mother, Martha, during Andrea's August 12, 2020 clinic visit. In looking back through the testimony that was provided as an attachment to the defendant's motion, and looking at the case law, there was no direct expert testimony that that was the cause of Andrea's passing. And this is not a case like, you refer to it as the Clamp case, but you all know what I mean, the one that was cited by the plaintiffs. This is not a case like that. This is not a Ray Simpson case, where the mere presence of the clamp is going to be something from which the jury could infer negligence that caused an adverse event that was alleged. In this case, there would have had to have been expert testimony that tied the lack of the interpreter to Andrea's death, and there was not that degree of testimony. So I'm going to grant the defendant's motion for directed verdict on that one allegation. So the defendant is also now asking for a jury instruction. That's at the bottom of page 6 of the defense motion. So let me ask the plaintiff, is the defense still asking for this instruction?
Yes, Your Honor, and I asked that it be given before Ms. Armstrong takes the stand, because the jury should understand why I won't be asking her about the interpretation
Right.
issue.
Right. Timing, I agree with, certainly, but does the plaintiff have any particular comments or any additions or deletions that you would like to make to the instruction?
That's fine, Your Honor.
I don't have any objections to that.
Pardon?
We don't have any objection to this instruction.
No objection to the way it's written and phrased?
No.
I would plan to add one word in here, on the fourth line. I would propose to add the word legal in front of cause. That I instruct you that failing to offer or provide an interpreter to Andrea's mother Martha during Andrea's August 12th, 2020 clinic visit was not a legal cause of Andrea's death and is no longer alleged as negligence in this case.
No objection, Your Honor.
No objection from the plaintiff.
Okay.
Rereading this again, this is the first time I've reviewed this. The last sentence, you will not hear any additional evidence on this allegation. I guess that's fine.
I don't think,
My
that
only,
evidence would only come from you, I would think.
correct. We don't have any issue with the additional language. I was just concerned that if there may be some evidence on rebuttal, I'm just trying to think ahead, but
Well,
I don't think there's any objection. That's
I mean,
fine.
I can foresee that mentioning that there was no interpreter at that visit might come up with a witness, depending upon who you're calling in rebuttal. That might be part of a question or something like that, but, that would be as more of a factual basis for a question. I think there's no question that factually there was no interpreter there, so if that's part of a question, if it's needed as part of a question, then yeah, the word interpreter may be mentioned, but I don't see, it's not going to, outside of that, they're not going to hear any, and that's not looking at the evidence of the allegation, since the allegation is no longer there. I want to add that because I don't want the jurors to in any way think that I'm making a medical determination here, because I'm not. I've simply made the determination that based on the evidence that was and was not presented, that the allegation about the lack of an interpreter was not a legal cause of Andrea's death. It is no longer alleged as negligence. So that's why I want to add that word in there. Thank you all. Please have seats. Ladies and gentlemen, good afternoon again. We're going to resume the witness very shortly, but first, let me instruct you. You have heard evidence that an interpreter was not offered or provided at the August 12th, 2020 appointment at Hillsborough Pediatric Clinic. I have ruled and I instruct you that failing to offer or provide an interpreter to Andrea's mother, Martha, during Andrea's August 12th, 2020 clinic visit was not a legal cause of Andrea's death and is no longer alleged as negligence in this case. You will not hear any additional evidence on this allegation. The remaining allegations of negligence are: 1, failing to measure and record complete and accurate vital signs during Andrea's exam on August 12th, 2020. 2, failing to send Andrea to the emergency department after Andrea's exam on August 12th, 2020. And 3, failing to contact the family with instructions to take Andrea to the emergency department at approximately 5 p.m. after receiving abnormal lab results.
That was a big loss. Like, all I can say is wow. The skill and the experience and the resources that the defense had. Like, it started with, like, my mom, that's, if you look back, it's like, well, that's what all their defendants or other witnesses. Oh, Martha, she knew she could have asked for an interpreter, right? So they needed that part for this outcome. And, like when Jeff was telling Melissa that Mr. Zamora was a certified interpreter, I'm sure that they were just hoping that he wouldn't present the case, that if my mom were to, testify, that if that would have been asked, that do you understand, or the outcome would have been different. Like, would you have said yes to an interpreter, or, anything like that, is what we needed to kind of keep that claim. And all I can say is this really opens up to me why the legal system is the way that it is, or now I understand why people can get away with things. I comprehend why that was the verdict, but I fail to understand morally, or like in real life, because, beyond this being specifically what happened to my sister, like, I really do have a passion about patient education. So definitely having an interpreter for a patient really will change the outcome of someone's health. How literate and how well do they understand a plan, and not just in healthcare. I think about that in just in general. Um, you know, if I also, like, many thoughts happen in that moment, like, if in if this would have happened in 2022 with that whole Medicaid OHP, legal change of how there is a requirement for an interpreter, like that, this claim have even been possible for, this motion for defense to have this claim dismissed. So, like, a lot of it is, when did it happen? I get it. It has to be pretty much black and white with what the law says. I totally um know that that's why we had to drop the claim. But it's hard for me morally, because, like, back to the reality of healthcare and how fast it is, sometimes people don't get interpreters because it's just going to take longer. Or, like, I can tell you, for me, because I'm certified to speak Spanish, where I work, oftentimes the immediate response that other people have for me is that there's a Spanish speaker, that they're going to leave the work for me. And I don't necessarily mind that, but when it comes to sometimes something not being touched for a day or two, even though they can get an interpreter really fast, that can also be a delay, just because they want they don't want to, it's almost when you're being rushed to have an interpreter that's going to probably take twice as long. I think subconsciously some staff might just avoid interpreter calls. But yeah, it's just this was a hard, just to kind of go through it, just because, again, not having an interpreter totally changed the trajectory. Like, that, how well does a patient understand their what the plan would be, so just the skills, the thing that I'm learning about, like, resources and experience, and how to get a job done, I guess.